Good evening, everyone. Welcome to the special immigration show brought to you by Sakshi TV. My name is Ranjit. We are here today with the attorney Chand Parvathaneni to discuss the latest updates, frequently asked questions related to H1B and green card. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. We'll start taking calls in few minutes. Before starting the show, I would like to repeat the disclaimer. This show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. Please reach out to attorneys for a case specific consultation. Before getting into the show, Mr. Parvathaneni, could you please briefly introduce yourself and we can take it from there?
Sure. Thank you, Ranjit, and thank you to all the viewers of Sakshi for joining today. It's a pleasure to be on Sakshi TV. My name is Chand Parvathaneni. I'm a managing attorney at Sim Parvathaneni and Brown Law Firm based in Dallas. So I've been practicing immigration law since 2011. It's almost 10 years. And during the course of my career, I've had the pleasure to represent in several thousands of H1B petitions and I14 petitions, labor applications. And it's been a pleasure working in the immigration law and helping a lot of people get their dreams fulfilled. And today I'll be here to just share my knowledge in employment-based immigration law and give you some updates and give you some pointers on what to do and what not to do to make sure your entire process, your H1B, till the day somebody gets a green card, the process is smooth and the pointers and steps one should take in the course of their green card journey.
Sure, thanks, Mr. Parvathaneni. Could you please, let's start the show, and could you please give us an update on most recent immigration changes and employment-based immigration updates and also about green cards?
Sure. Just to briefly give an update on what's happening in the last few days, last month or so, the biggest thing is the new H1B cap filings. So the deadline has ended on June 30th. So anybody trying to get the H1B for the first time, also known as the cap H1B filings, the deadline was June 30th. So everybody has finished their filing as of last week. And for the next few weeks, few months, a lot of people will be anxiously waiting for their adjudications to see their approvals and get started on their next part of their process. So the CAP 2022 filings for H1B have finished as of June 30th, 2021. And so that's the big update on the H1B side. And coming to the green cards, so the monthly bulletin for July, it has been released. And as expected, the dates were very promising. We saw very good progression in dates. EB2 advanced to June 2011. EB3 also progressed to January 2013. So it is very encouraging. And whatever news has been coming out of Department of State, it looks like things are following what is being predicted and dates are progressing pretty quickly. And from what's coming out of Department of State, there should not be any retrogression, at least for the next 1 year. And until September 2022, we should not be seeing any retrogression, which is great news for Indians because we saw the dates really bad in the last 5-10 years. So it's finally time when the dates are moving ahead. And the predictions are it is going to continue to be that way in the next couple of months. And that being said, USCIS recently released the I485 data. So the I485 data was released in the last few days, and this is very important because for the current fiscal year, we're expecting about 262,000 green cards for the employment-based category because of the spillover. And any numbers that are not used in this fiscal year, they will be wasted. So it is very critical that USCIS process the green cards as quickly as possible before end of September, because if they do not, the numbers will be wasted. The numbers for the current fiscal year will be wasted. So based on this, recently USCIS has released the I485 data for the first quarter and the second quarter of the current fiscal year. And what we are seeing is they're very, very slow. Only 27,000 green cards have been issued in employment-based category for the first quarter of the fiscal year, the current fiscal year, and about 17,000 for the second quarter of the current fiscal year. And USCIS currently has about 262,000 green cards to be issued. and what we are seeing is about 50,000 issued so far. So we only have one more quarter, because the current quarter is going to end on September 30th, and it is highly critical that USCIS gets speeded up in its process, or we will waste the green card numbers. That being said, every year it is very common that the last quarter things are very rapid, things move quickly. So we can expect to see a lot of green card approvals in the current quarter that will end on September 30th. And it will be interesting to see how many numbers will be wasted. We just hope that very few numbers will be wasted, if not almost none. But unfortunately, the reality is that numbers will be wasted. And whether it will be 20%, 30%, 40%, we don't know. But our guess is at least 20% of the numbers might be wasted. And we just hope that USCIS moves very quickly in the adjudications. And any numbers not used by the end of September, they are wasted. And again, the next fiscal year will start on October 1st, 2021. I think that's all in terms of the updates for this current session.
Yeah, one quick question. The USCIS data that's been released, it's only for the first 2 quarters, right? The third quarter data is, I believe, is not yet released.
That is correct. And the first quarter is basically for the quarter starting on October 1st till the end of December, because the fiscal year for immigration, it starts on October 1st. So when we say the first quarter, it is October 1st to December 31st. And the second quarter is from January 1st to March 31st. And the data has been released only till the end of March. And starting from April, we don't have the data yet.
Okay, sounds good. So we have a caller. Let's take the call and then we can go back to questions. Hi, Kumar. Welcome to the show. Please go ahead and ask your question.
Hi, Chan Parvathaneni. Good afternoon. My question is about I-140. So my question is like, I am now working on X company and they have did my perm on I-140 and completed 180 days. So now I got a full-time opportunity which I need to go to other company Y, and the company is not providing me immediately the GC, and they don't want to do now perm and I-140. So if X company revoke or withdraw my I-140, can I use for the future extensions and transfers?
So is your 485 filing also done?
No, because my current date is not came. Now priority date is May 2020, so they didn't start it.
Got it. So the current rule is that once 180 days elapse after the 140 is approved, the date is yours. The I-140 approval is yours. So technically, even if the company withdraws or revokes your I-140, the date is yours. And what that means is for any of your future extensions or for your spouse's H4EAD, you can continue to use your I-140 approval. So from your perspective, just look at the approval date, wait for 180 days. And after that, even if the company withdraws, you should not have any problem. And what that means is you're good to move to a different employer. The only caveat is that the new employer eventually will have to do another I-140 because that will be the basis of your I-485 whenever your dates are current.
Okay, understood. So one more question is like, if my other company which is not doing my GC, and if I transfer to other company, and when the current dates came, I have an employer to do. So within I-485 date came, I should be with the employer to having I-140, right?
That is correct. So when your dates finally become current, at that point of time, you should have an employer who has done the perm and willing to sign off on the 485J. If that is the case, then you should not have any problem. And since your date is 2020, I think you have some time. So I think you have some time before you find an employer who's willing to sponsor your green card.
Yes. Okay.
Okay, thanks. Thanks for your advice. Coming back to the H1B, I know the H1B first round of lottery has been done, and last year there was a second round of lottery around July, August, I believe. So do you expect this time there could be a second round of lottery like last year, or what are the chances of having that?
Sure. So in general, we have 85,000 H1B numbers available every fiscal year. And typically USCIS, when they do the round of lottery in March, they take a little bit, they don't really only go for 85,000 numbers. they pick more than 85,000, and typically it is close to 100,000 H1B numbers, registrations, based on the data they have released. So again, I mean, it is very common that many people do not file for whatever reasons. Maybe the company had a change in mind, or the employee is not willing to join the company. So typically, once the filing deadline is over, the filing deadline was June 30th, 2021. And now the deadline is over. So now USCIS exactly knows how many people have applied and how many people have not applied. So in the next coming few weeks, what would happen is USCIS would analyze their numbers and figure out how many people have not applied, even though they have been picked up in the lottery. And last year, in the second week of August, they did a second round, second lottery, and released those numbers. So a similar thing can be expected this year. So probably in the month of July, they're tallying up their numbers. They're looking at how many people have not applied. And in August, we can expect a notification on the second round. And more than likely, we will see a second round, second lottery. And from an employer perspective, from an employee perspective, they should be looking at the employer's My USCIS portal. Because right now, if they look at the portal, it will show the employee's name as the status as submitted. So once the second lottery is done, the status will change to selected. And once the notification comes that a second lottery has been done, people should go into the employer portal and then look at the registration status. And definitely we can expect something coming up in August, most likely August first week or second week. And then I definitely do expect to see a second lottery come out.
Thanks, Mr. Parvathaneni. Another question is, a lot of people whose H1B is not picked in the lottery and who are on F1 and whose OPT is about to expire, do they have any other options to stay in the country? Like few people consider doing a second master's on CPT, day one CPT. How safe is that, and what all options they have just in case if their H1B is not picked in the lottery and they don't have any OPT or anything left on the F1?
Sure. So for people who are picked up in the lottery, if the H1B petition is filed, they are in status to, and they're allowed to stay back in the country as long as the H1B is pending. But for the unfortunate few whose H1B is not selected in the lottery, they have to make sure they are in status to stay back in the country. And typically, a lot of them will be having valid OPT. And the folks that have valid OPT, they can stay back in the country as long as their OPT is valid. Only thing is they have to make sure that they're employed as per the OPT regulations. And as long as they're employed in their field of study, they're allowed to stay back as long as their OPT is active. And once OPT ends, they have a 60-day grace period to depart the country in general. And for the other people whose OPT has ended or about to end, or people who are under the grace period. So there is a 60-day grace period once the F1, the program ends. So for those people, the only way to stay back in the country is typically, again, to make sure that they join the school and pursue their studies or change to a different status. And typically, most of the people choose to continue their F1 studies. And what that means is they have to make sure that they're enrolled in a course of study, a full course of study, and follow the F1 regulations. And among these people, some people also want to keep working while they go to school, and that is permitted. So under the CPT program guidelines, people can work and people can go to school. The only caveat is that the CPT work, that work should be an integral part of the program, whatever their program is, either their MS program or their PhD program. It should be integral to their course of study. It should be in the line of study, and it should be approved by the school. So the school has to approve the CPT work authorization. So assuming that is followed, people can go to school, people can work. And the most important thing to keep in mind is that CPT is allowed, but there are very, very strict rules. So the school has to be authorized, and the students, they have to make sure that they attend classes. One has to attend classes full time to make sure they're able to work under the CPT program. So as long as people are following the guidelines, working under the guidelines of CPT, typically it's not a problem. And many people continue to work on CPT and go to school at the same time. And the only thing is, as long as people are following the rules, making sure their attendance is in order, they're not missing any classes, they should not have any problem. So the only thing is, make sure you check with your school DSO, make sure your service is active. Because what happens is some people, they don't realize that their F1 program is ended and their service terminates. And after that, they try to get back to a CPT program. And that is a very difficult thing to do. So while their service is still active, they have to make sure they transfer their school or enroll into a new program. Because once the service terminates, it's very complex. So anybody that's not selected in the lottery, start talking to your school DSO, make sure your service is active. And if you want to take CPT work authorization, make sure you're in touch with the DSO and work under those guidelines.
Thanks, Mr. Parvathaneni. Coming back to the other topic, a lot of people are facing issues is the travel ban. Could you please let us know about the travel ban and, still H1B and F1 and tourists, what all are still under the ban, who are exempt, and what are the ways if someone got stuck in India to come back to US?
Sure. So the current ban came into effect on May 4th. And due to the unfortunate COVID pandemic situation in India, the travel ban was initiated. And starting from May 4th, the ban is in effect. However, according to the current rules, the ban will be reviewed every 30 days. And at some point of time, the ban will be revoked. But until the ban is revoked, the ban is in effect. And what that means is the ban is currently in effect, but the 30-day review period is coming up. So more than likely, it will be reviewed this following week. And hopefully, we'll see some good news. Currently, I think the way the ban will be removed is if the pandemic is in control. And based on what we're seeing in India, looks like the pandemic is getting back in control. The central government and all the state governments are working very hard to make sure the pandemic stops as soon as possible. The impact of the pandemic is lessened as much as possible. And from what we are seeing, at least in the last few weeks, the cases have come down and things are getting back to normal again. And the lockdowns seem to be helping out. So hopefully, once the ban gets reviewed after the 30-day period, which since the ban was initiated on May 4th, the first 30-day period was June 4th. The next 30-day review is this week. Hopefully, the ban is removed. But if the ban is not revoked, we should expect the ban to still be active and look at the exceptions. So currently, there is an NIE exception for somebody that's on H1B who is stuck in India, who's trying to come back to US. They can apply for a NIE exception. And what that means is they have to send out an email to the US consulate and list out the reasons why their work is in national interest. And if they're working in critical infrastructure projects, they're eligible for an exemption. And a lot of people have been applying for NIE exemption and have been getting exemptions. That is one way to go about the ban. The other way is if somebody has a child who was born in US, a minor child who is born in US, they're also exempt from ban. So a lot of H1B employees who have children who are born in US, they're allowed to use that reason and come back to US. And a couple of other people, what they've been doing is they're staying back in a third country for 15 days. So for example, they go to Mexico or they go to Dubai and stay for 15 days. And once the quarantine, because the ban is only for people who are in India for the last 14 days. So if somebody is able to stay in a different country for at least 15 days, they can come into US without the ban. So whoever are able to stay in a third country for about 15 days, they're also exempt from the ban currently. So these are the couple of ways people can go around the ban. But for other people who are not able to use these avenues, I think we just have to wait and see how the review goes and if the ban will be revoked. And definitely at some point of time, the ban will be revoked. And we are just hoping that happens as soon as possible.
Thanks, Mr. Parvathaneni. Follow-up question. The exceptions you are saying about the NIE having kids and all are for especially the ones who already has a visa stamp. So what about the people who don't have a visa stamp and got stuck in India? So are they able to procure any appointments based on the NIA, or are the appointments open at all? Are the Dropbox appointments open at all? We are hearing that people who are eligible for Dropbox are not able to book a face-to-face appointment usually. So, how this works, is there any way that they can get hold of appointment if they fall under the NIE?
Right. So the current policy is that they have to request for an expedited appointment because only expedited appointments can be requested currently. So they have to request the expedited appointment by giving the expedited appointment reasons. And then when they attend the interview, they have to show the reasons. So they have to come up with that NIE letter. So typically it's a letter from the client or letter from the company listing out all the reasons why the visa has to be expedited and why they're working in a project of national interest, and then attend the visa interview. So what that means is if they have an expedited reason, they have to show that reason and then get an appointment. So only people who have a reason to expedite their H1B appointment, only those people are able to get an appointment. And at the time of the interview, they are required to show the reasons for expediting.
Got it. Now, another question a lot of people have in mind about, we all know very well that a lot of people have downgraded from EB2 to EB3, and they are all in line from quite some time. Now, a lot of people who probably have got new offers, they want to move out. So what are the precautions or, they have to take, especially when the downgrade is pending, even though if it's past 180 days? Is it recommended to get it approved and only then move on, or what are the implications that someone will have if they move when the downgrade is pending and it's past 180 days, but there is always a threat that employer can withdraw the I-140? What happens? And can you please let us know about the implications?
Sure. So so there is a process called AC21, and people can utilize the AC21 portability provisions to change the employer. So even if some at the day of filing the I485 green card application, they have an employer, one is not stuck with that employer. So the current rules state that after 180 days, the I485 application is received by USCIS. So one can take a look at the I485 receipt, and they will see something called received date. So look at that received date on the receipt and then add 180 days. So once the 180 days cross, typically one is free to change employers in general. The only rule and the only precaution that one has to take is that whatever new job offer that they're accepting, it has to be in the same or similar line as what was filed during their green card application. So assuming it is in the same or similar line of their green card application, one is free to change their employer after 180 days. That's a general rule. However, the issue is if the 140 is approved, there is no issue. They can just go ahead and change their employer. And typically, it's a very smooth process. The issue is when the I-140 is not approved and people want to change their employer. The problem is if one change their employer and down the line that 140 gets denied, there is a problem. So the general recommendation is that they should at least try to get that I-140 expedited for people who have done a downgrade, because now it's been a couple of months. They should be able to upgrade. They should be able to upgrade their petition, and more than likely it will get accepted, even though the original labor is not part of their I-485 downgrade filing. So the best course of action is upgrade your I-140 downgrade, get an approval, and then change your employer if needed. And again, in general, a lot of employers do not revoke their I-140s. So if somebody changes their employer and down the line, if I-140 gets approved, typically there is no issue. The only issue is if the I-140 is not approved and somebody changes their employer, and the employer down the line does not answer an RFE or revokes the I-140 before it is approved. So that risk is there. And to mitigate that risk, the recommendation is try to get it expedited, get an approval, and then make a career or a job switch.
Thanks, Mr. Parvathan. We have a caller, Suchita from Michigan. Let's take the call and then we can continue. Hi, Suchita. Welcome to the show. Please go ahead and ask your question.
Yeah, hi, thank you. Hi, good afternoon.
Hi.
Yeah, actually, I have a question regarding visitor visa.
Mm-hmm.
Actually, my cousin wedding is there in August ending in US. Mm-hmm. So he's expecting his father to come, who is in with the visitor visa. So he stays in India. So is there any chance for him to come here because of these restrictions. I just wanted to know, can he apply through NIE, or would you give any suggestions?
Sure. So NIE might be a little bit difficult for the reason that you mentioned, but what
Okay.
other people have been doing in a similar situation is they can go to a third country, typically a country like Mexico, because I know some people who went to Mexico. Their parents came to Mexico. They stayed in Cancun for about 14 days, or in Mexico City for 14 days, because there is a direct flight from Bombay to Mexico City. Spend 14 days in
Okay.
Mexico, and then you're outside the ban, because now you have not been in India in the last 14 days. And then once you're outside the ban, you can come into US. So that is one easiest way for somebody on a tourist visa to come to US, by staying in a third country for 14 or more days. The other option is there will be a review of the current ban in the next few days. And hopefully, if the ban is reversed and the ban stops, then they can probably directly fly into US. But if the ban continues, I think you might want to explore staying in a third country for about a few days, and then finish off the quarantine period for 14 days, and then come to US.
Oh, okay. Okay. Thank you, sir.
Thanks, Chitra. Thanks for the call. Going back to the our green card process. So a lot of people and a lot of families have been separated because of the ban and all. So hypothetical situation. Let's assume that a spouse is in India and the principal already filed a I485 and it's pending. What are the options the spouse has in terms of adding it to the green card application when they are not in the country?
So if the spouse is not in the country, they can request consular processing for the spouse, and it's an easy process. So a request has to be sent through the NVC, and NVC will notify the embassy, and that is the easiest way to get the spouse added to the green card process. Uh, as one of the options. The other option is the spouse, if the travel ban, and she's able to overcome the travel ban and come to US. uh, Ideally, it is better that she comes to US and an adjustment of status application is filed. That is the easiest way if she can get back into the country. But the other option is you can go through the NVC, the National Visa Center, and have them contact the consulate and go through the consular processing to add her to his green card application.
Is that process should be done only before the green card is approved, or let's say meanwhile the green card gets approved? What are the other options? They can still do that same process?
They should still be able to do it even after the green card is approved. And also, once the green card is approved, there is another option. There is she will qualify as spouse of a green card holder, and based on the priority dates, that's another way to get the green card.
Okay, thanks, Mr. Parvathaneni. We are towards the end of the show. Again, thanks for your time. Thanks all the viewers for the calls and watching the show. It was a great session with interesting topics and questions. Please call in for other shows, or please contact Mr. Parvathaneni if you have any questions. Again, thanks again for your time. And this is Ranjit signing off. Bye-bye.
Thank you very much.